My name is Bob Bond, and I want to talk to you for just a minute about the new estate tax law. As you may have heard, Congress finally got around to passing the new estate tax rules. So this was done just before Christmas in 2010. The law goes into effect for 2011 and 2012, and after that it sunsets again. So there's, at least after 2 years, there's going to be uncertainty again about how this particular law works. But for the moment it is very favorable. It's the most favorable estate tax laws that we've had. The exemption for a person is $5 million, and if the estate exceeds $5 million, the tax rate on that, the amount over $5 million, is 35%. So that's the lowest tax rate and the highest exemption that we've ever had, unless you count this 2010, where we had this anomaly where there was no estate tax at all. A rather unexpected event in the law. But at any rate, the new law should relieve a lot of people's concerns that the estate tax exemption was going to return to $1 million per person. And of course that had a lot of people jumpy about whether they need to revise their estate planning or not. Now, for a married couple who have tax planned wills or trusts, trust planning, they will be able to shelter $10 million for their children under this law, so $5 million each. In addition, there's another change in this law, and it's not been this way in the past. And it goes like this. In the past, if you didn't have tax planning in your will or trust, and the husband or wife just left their property to the surviving spouse, there was a tax trap. And the tax trap was that the husband and wife would only get one of their two estate tax exemptions unless they created a special tax planning in their own will or trust. And what the tax planning is instead of leaving my half of the property to my spouse, I would leave my half of the property to a trust. And we could create this trust so the property was just short of an outright gift to the surviving spouse. The surviving spouse would have access and could have access and control of that trust, but technically that property would not be part of the surviving spouse's estate. And it would have the effect of being able to use the spouse who passed away first's exemption on that trust. And that was the way we were able to get the exemptions for both the husband and the wife in the past. Now, the way this new law is written, though, it's changed and it's more favorable, and that is that if you have a married couple and one spouse passes away, the surviving spouse can use the deceased spouse's exemption. So what this means is that for the next 2 years, it's not necessary to have tax planning in your will or trust in order to get both exemptions. Now, many of my clients have tax planning in their wills or in their trusts, in their living trust agreements. So the question is, well, do we need to change our planning, or does this somehow mean that there's got to be an amendment to our planning? And I think the answer to this is no. Like I said, the current law is only in effect for 2 years, so we're not certain how it's going to play out after 2 years, and we might get back into the situation where you would need tax planning. In any event, the creation of the trust, for those of my clients who have that, where they have tax planning in their trust, the creation of that trust will not create a problem for the couple. In other words, the planning can stand as it is. However, if clients, when they get ready to revise their planning, update it, or reviewing it, we'll look at that again and see if it's desirable to do away with their tax planning or not as part of the routine there. But at any rate, so that's a kind of a new development. At any rate, the point is I want to let my clients know that this change seems like it's very favorable to most of our clients. It means most of my clients don't need to do anything special to change their planning or to create some new devices to reduce estate tax. So we're fortunate that the law turned out the way it is, and we hope it'll stay that way after the 2 years as well. Thank you.